Right now at 5:30, leaders in several states are engaged in abortion debates. The battles are taking place in courts, in the halls of government, or on the local level. And the federal government is weighing in too. 8 states held primaries yesterday, the first round of elections since the Supreme Court overturned Roe versus Wade. In Colorado, Joe O'Dea, a Republican who's voiced support for some abortion rights, beat an anti-abortion rights opponent in his U.S. Senate primary. Meanwhile, Wisconsin's Democratic leaders filed a challenge against their state's abortion ban statute dating back to 1849. Some state judges have already temporarily blocked those similar trigger laws in Texas, Utah, and Louisiana. The city of Alexandria has already begun to fight to protect abortion rights in their city. The city council responded to the Supreme Court ruling by unanimously passing a resolution that allows the city to take action to promote abortion access. But there were some interruptions during the meeting.
Have you been part of a clinic? Most of the women.
All right. Thank you. Have a good evening, please. Thank you. Councilman Aguirre, conclude.
Supporters and opponents of abortion rights were also in attendance at that meeting. Eventually, some were removed by security. As for the resolution, it states the council's opposition to the Supreme Court's decision, and it calls on Virginia lawmakers and Congress to act to protect the right to end a pregnancy. This also authorizes the city's manager and attorney to help ensure abortion services remain available in Alexandria. Supporters of abortion access have long said birth control and same-sex relationships would be at risk if Roe v. Wade was overturned. And now a prominent voice on the court is elevating those concerns. Abby Larico is here to verify which opinions really carry weight when it comes to a Supreme Court ruling.
Dobbs versus Jackson Women's Health was decided with a majority opinion that says the decision is specific to the right to an abortion. But a concurring opinion by Justice Clarence Thomas brings up other issues because he writes that the court should reconsider precedents set by cases allowing for legal birth control and same-sex relationships and marriage. We turn to the Cornell Legal Information Institute, the Administrative Office of the U.S. Courts, and attorney Tillman Breckenridge to find out first, what is a concurring opinion? U.S. Court procedure explains, quote, if a justice agrees with the outcome of the case, but not the majority's rationale for it, that justice may write a concurring opinion.
That happens quite often.
Breckenridge explains they're a way for a judge to get on the record with their interpretation of the law and the type of arguments they're open to in the future.
It can be used as a signal to bring new cases on a similar type of issue using the same reasoning. Now, it also can be an opportunity just for a justice or a judge to say to his or her colleagues, this is where I'm coming from on this.
Now to verify, does a concurring opinion set legal precedent? Sources say no.
They don't have precedential value. They don't control the law in any way.
That doesn't mean they're unimportant. Cornell's Legal Information Institute explains, quote, concurring opinions are not binding since they did not receive the majority of the court's support, but they can be used by lawyers as persuasive material.
They can be used and cited in later opinions to say this justice made this point however many years ago. And I agree with that. It's a foundational document sometimes for later decisions of the court.
Appellate courts can only make decisions on cases that are brought to them. So while Justice Thomas says he thinks certain issues should be reconsidered, someone would have to take cases questioning the legality of birth control and same-sex relationships all the way to the Supreme Court before they can actually weigh in. With your Verify, I'm Abby Larico.